The topic we're going to address now and that I'd like to welcome you to is effective trusteeship, ethics, including ethical issues in financial management, and avoidance of conflicts of interest. With me on the dais today are three very distinguished lawyers. To my left is Kabi Caputo. Kabi is an Austin lawyer who has a wide-ranging legal practice that also includes and emphasizes general counsel services to both schools and colleges. Kabi has also dabbled in the political arena and has been elected to a local city council. And finally, Kabi received his Bachelor of Arts degree from UT Austin and his JD degree, that is his law degree, from the University of Texas School of Law. He's been a lawyer for more than 20 years. To my far right is Mike Godfrey. Mike is the Chief Legal Officer at Texas A&M University Health Science Center, and prior to joining that esteemed institution, he held similar positions with Texas A&M University System, the University of Texas System, and he was also in private practice as general counsel to FINA, a petroleum and petrochemical company. Mike Godfrey holds undergraduate and law degrees from the University of Texas at Austin. To my immediate right is Fernando Gomez. Fernando has served as Vice Chancellor and General Counsel to the Texas State University System for some 22 years. Prior to joining that system, he had attained tenure at Michigan State University and later served as an Assistant Attorney General in both Michigan and Texas, and also, with a hankering to go to the left coast, served as General Counsel for the California State University System. Fernando Gomez has his Bachelor of Arts degree from the University of New Mexico, his JD, and a PhD from the University of Michigan. Please join me in welcoming these very esteemed colleagues. What I would like to do at the beginning is mention a couple of things. One, the training that we're presenting today, not just us, but the entire day, does satisfy the training requirement for newly appointed regents and newly elected trustees pursuant to the Texas Education Code. However, what this training does not do is satisfy the open government requirements that is imposed by the Texas Government Code as of about some 6 years ago. You need to become even more familiar with the Public Information Act and the Open Meetings Act, and there are two 1-hour trainings that you can access, if you haven't already done so, through the Office of the Attorney General's website. And they, as I said, they're short. They take 2 hours total, and they're entertaining, they're breezy, and they are fact-filled. I strongly encourage you to take a look at them. We feel that the training today is particularly timely given the events of the last 6 to 12 months, with the turmoil at the University of Virginia, with the horrible scandal at Penn State University, with the very recent decision by the Fifth Circuit Court of Appeals on the Texas Open Meetings Act, with the heightening interest in open records and the use of private, non-public, non-government issued telephones, computers, etc., to communicate by either email or some other means. All of those are burning issues today, and all of those issues will be addressed during this training. So with no further ado, what I'd like to do is turn the program over. We drew straws to see who would go first, and Fernando Gomez has the honor of speaking first today. Fernando?
Thank you, Bill. Bill, thank you for the kind words, and want to say also that we very much appreciate in higher ed the lawyers that have the opportunity to work with, and Bill, he provides great leadership and insight on many of the issues that we deal with, so we do appreciate him tremendously. I want to talk, you've got two handouts, duties and ethics of public sector board members in your materials, and also a synopsis of and a reproduction and a synopsis of Texas Education Code Chapter 51. And first, let me say a few words about what these universities are. They're very complex organisms. By any measure, even the smallest of these universities is a very complex, very large enterprise with operating budgets in the tens of millions, with physical plants in the hundreds of millions, issuing, in some cases, billions of dollars worth of public debt. Tens of thousands of employees, many of these institutions, by any measure, they do anything that FINA does, or Dell Corporation, or AT&T. They purchase property, they purchase goods and services, they hire employees, they purchase real estate. There is a tremendous power that comes with being a member of a board of regents or trustees of these institutions. We talk about ethics, and why do we need ethics? Why do we need to have the training that we have? Because you wield power. You have plenary authority over these institutions. You can condemn a piece of property. You can issue debt that, indentures that will encumber the institution for decades. These are awesome responsibilities that you bear collectively. Basic questions I think you should ask yourself as you approach your trusteeship or you're becoming a regent. One, what do I have to offer in terms of knowledge, experience, relationships perhaps, my own unique vision of what this institution can be. Two, why do I want to serve? Ask yourself way deep down, what is it that motivates this service? What is guiding you to do this service? And I suspect that the answer will largely be the same. To help the state, to help the students of the state, to help create a path for this generation and into the next generation. Where can I best fit? Where can I best contribute? You have an independence of judgment as a trustee or as a regent. You're appointed by the governor of the state of Texas with the advice and consent of the Senate. As such, you are state officers. And generally, you can be removed from office only through articles of impeachment. What does this mean? What this means is that the expectation is that you will fulfill your duties in accordance with your judgment and your collective judgment as to what is in the best interest of the institution. There is a line that sometimes is not too bright between what policy is, or the setting of policy, and administration, or the execution of that policy, and we're going to talk about that. The handout that I put in your packet, it's a one-page sheet. It looks like this. It has some squares in it, or rectangles, and it says it's Texas Education Code Chapter 51. Let's begin first with what the law says are the responsibilities of governing boards in Texas. Now, the traditional role, what I've given you in black on the left is the law itself, and then I've synopsized it for you on the right. In section 51.352, it says that the traditional role of governing boards is, and it says 5 things. 1, to preserve institutional independence and administrative authority. I think we have a good legislature. We have had a good legislature for many years. It's a far-sighted legislature in many of the laws and statutes that they pass. And I've seen this going to national meetings, the progressiveness of what we have in Texas, our vision as a legislature. And I say that somewhat by way of preface, because the other side is that there may be pressures to bear. There may be phone calls that you receive from members of the legislature that may have certain ideas as to how these institutions should be governed, or as to this issue or that. There's an independence of judgment that you have to exercise. That duty, that responsibility is given to you solely and collectively as a board. So you preserve institutional independence and the administrative authority of those that you have put in place as presidents and employees and administrators to govern and manage your own affairs. Secondly, you are to enhance the institution's public image, to represent it to those around you, to represent it in your communities, to do everything you can to make sure that that image is preserved. 3, you are to act as a liaison with that community, to explain the institution to the community and to serve as a bridge between the community and citizens of the state and the institution. 4, you are to nurture each institution. If you're in a multi-system situation, to nurture each individual institution, but to help it grow. And 5, you are to state a clear mission. That's a board prerogative. What should this institution be? You're going to work with the administration. There are in this room people, university administrators, presidents, vice presidents, council, and others that have spent a lifetime, a career, working in these institutions of higher education. They understand them, as many of you have spent a career and a lifetime building some very successful businesses, law practices, medical practices, dental practices, other professions that you're in. Contributing as Mike was an executive with a major company, growing these institutions that you were with. That is the commitment that the people that oftentimes you work with will have. So you don't need to do it alone. So you have to find a way of striking a balance that makes some sense. Section B, if you go down the right-hand column, you are to provide policy direction. Your statutory duties are basically 5-fold: to establish goals, to name the chancellor or president, to name and assist the chancellor or president. And the law understands, and these are very important words, not to overguide the president or to micromanage the president, but to assist, to create an atmosphere where he or she is successful, to set admission standards, and to make clear to the coordinating board, the position of the board of regents or trustees on important matters. Now that's statutory. Your other handout is basically 4 points: general duties and authority, duties and ethics of public sector board members. There are 4 points. I like symmetry. There are 4 major points: general authority and duties, conduct at board meetings, conflicts of interest in relationships with the chancellor, staff, and presidents. And each one of these has 4 general duties. Let me talk about the general operational authority and duties. You have a duty of loyalty. You have to be loyal to the institutions or the interests of the institution. Now, one of the things, Bill mentioned Penn State, the free report that was issued in that case. Now, I think that's a fact situation that's very unlikely to be replicated anywhere else. I'm not saying it's impossible, but it's also a fact situation that may arise, that I have seen arise over the years in different ways, and I'll tell you why in just a second. But that report said what they found, one of the critical findings at Penn State were that the institution fostered a culture of reverence toward an individual that led to total disregard for children's safety, and that a powerful president first sought to protect the university's reputation at the expense of the safety of the children. Now, supposing you have a university president that's been in place for 30 years, been wildly successful, has grown the capital fund of the institution, has brought donors, has grown the academic programs, and that president makes a mistake, or there is some irregularity that comes up in the finances under the stewardship of the president. It may not even be the president's fault, but it comes up. It's a very natural human reaction to say, wait a minute here, to circle the wagons, we have to make sure that we take care of the president, we have to make sure we look after his interests. That's the approach they took at Penn State. That's not the approach you have to take. Because the loyalty, the primary loyalty that you owe is not to the president. It's to the institution, it's to the better interests of those students that are in that institution. I've seen situations where a president gets asked to leave. That happens occasionally. And oftentimes board members who are very closely associated with that president, and there's nothing wrong with that. You should develop and foster those relationships, but oftentimes a reaction is, now wait a minute, you can't do that. This is wrong. Well, maybe it is, maybe it isn't, but the board acts only one way, through a majority vote where a quorum is present at a meeting properly called noticed meeting of the Board of Regents or Trustees. And it's an easy thing to ally yourself with the president against the board. I have seen that happen. I've seen that happen more than once by well-intentioned people. And oftentimes the board chairman, if he or she is strong, is able to reel the person back. But you have to keep that loyalty firmly in mind. The duty of unity. No single member of the board can speak for or bind the board. The chairman is the face of the board, whoever he or she is, and that's tremendously important. But the president is not the board. He can speak for the board, or she can speak for the board in between board meetings, but only insofar as he or she knows that this is an advancement of board policy. The president cannot make alignments to bring other institutions into the system, if it's a system, or to go out and decide, well, we really ought to have a medical college and contract with somebody. That's something that is not given. So there's a duty of unity. Let me talk about conduct at board meetings. You have a right to speak as a trustee or as a regent. You have a right to state your opinion. You have a right to state a dissenting opinion. In fact, so important is this right that the government code, not the education code, says that if you have a dissenting opinion, you have a right to have it read into the minutes and to put into the minutes and to be preserved. So that process of dialogue, nobody's asking that you agree on everything, and you won't agree on everything, but there has to be that mutual respect. Confidentiality. You have a duty of confidentiality to the board and to your colleagues. When you go into executive session, the executive session is allowed to be private and that privacy should be respected. I have seen situations where folks disagree with what has happened or what their colleagues have said, and sometimes speak out of turn. If you're talking to Cobby or Bill or Mike in executive session, especially as counsel, and a member of the board goes out and says what was discussed in executive session, you may well lose that privilege, and that may harm the board. Finally, going very quickly here, the relationship with the chancellor, staff, and presidents. Mike is going to talk about conflicts of interest and other issues. The executive's role, policy. What is policy? Examples of policy that are within the board's purview: the opening of a satellite campus, the presidential chancellor performance, whether to sell land on an interstate. I had a regent once, as a lovely lady, a very aesthetic lady, very gracious, decided that she wanted begonias planted outside the tennis court. And she told them about it. She went to physical plant and she told them about it. And you know what? They planted the begonias. But that's not a regental function. But if you tell them, I like begonias, you can or I don't like the color of this room, you know, they're likely to change it. But they do listen to you. What's not policy is a termination of a vice president or a dean, student discipline, strategies on recruitment, retention. Now, that doesn't mean that you don't get to talk about that. What it means is that you work with your administration. If you have an issue, we had a technology person on the board a while back, and he wanted a technology committee. And working with the chancellor, we created one that has been a very important part of our operation ever since. So fundamentally, that's the duties and ethics of board members in a nutshell. And there'll be time for questions later. Thank you.
Thank you, Fernando. As Fernando just mentioned, hopefully we allowed enough time that we'll have ample time for questions at the end of the presentations. But I've been provided a few questions that people have an interest in, apparently, and so I'm going to ask these questions at this point so that they stay current with the speaker who just concluded their remarks. In that regard, and you know, it was pointed out to me, I forgot to introduce myself. I'm Bill Franz, the General Counsel of the Coordinating Board. So let me now ask you a couple of questions. Does the law define specific duties or responsibilities for governing boards? And if so, what are those duties and responsibilities?
Well, the duties fundamentally, breaking them down, are to act as fiduciaries over the assets and the institutions that the board member is charged with overseeing. As I've mentioned previously, preserving the independence. Thirdly, I didn't mention establishing the mission and policies of the institution. And probably the most important function is appointing and discharging presidents and chancellors.
Okay. Does any governing board, speaking collectively, or any individual member of a governing board have a general mission to advance higher ed in the state of Texas?
No, you do not have a mission to advance higher education in the state of Texas. You have a mission to advance your particular institution, and in so doing, you will advance the mission of higher ed in the state of Texas. But that broader role is given to the Texas Higher Education Coordinating Board and to the Commissioner of Higher Ed.
Let me ask you one other one. Relatively recently, we've seen student regents appointed, student trustees, a student member of the coordinating board. Can you explain for everybody what the rights and duties are of the students on the board?
The student regents fundamentally, let me give you two mays and two may nots. One, they may attend and participate at meetings and other functions, board functions. We allow them to be, or in executive session, I believe everybody does, but that may be an error, but at least in our system we do. Two, they may have access to all materials on the same basis as other regents. Third, those are the mays, and the may nots are that they may not vote on issues before the board, and their attendance is not counted toward a quorum of the establishment of a quorum.
All right, thank you. What I'd like to do now is turn to Kabi Caputo and ask him to speak to us on issues of open government. In other words, the Public Information Act, the Open Meetings Act, et cetera. Kabi?
Thank you, Bill. I want to kind of talk to you a little bit philosophically first about open government. I don't know what that is. Oh.
Total transparency.
Total transparency is it's a goal that the state has. Too often people who are in elected office or appointed office view the open meetings law or the open records law as problems, hurdles to overcome, difficulties that make our lives, harder. And life is easier if you just accept that we have to be open and that everything we do is going to be scrutinized at some time or another, and that it's best if we just operate as openly and transparently as we can at all times. So I'm going to talk to you a little bit about issues that have arisen in the open government area. The most recent thing that's happened that's somewhat interesting to us lawyers, and I'll kind of go through it quickly for y'all, is that a number of cities challenged the Texas Open Meetings Act in federal court, contending that it violates the individual city council members' rights to free speech. That by limiting where and when they can talk about city business, their free speech rights have been substantially hindered. And they brought a federal lawsuit in San Angelo. They lost there. Judge Janelle wrote a pretty scathing opinion, not really accepting any of their arguments. It went to the Fifth Circuit, and the Fifth Circuit ruled a week ago today, upholding the open meetings law and saying it does not violate the First Amendment rights of the elected or appointed officials. The specific things they talked about were that ultimately the open meetings law is nothing more than a time, place, and manner restriction, which is generally allowed for most forms of speech. That it doesn't say you can't talk about anything. There's no content-based, prohibition on what you can speak about. It's completely content neutral. It just says where and when you can have these discussions. And given the state's keen interest in transparency of government and the state's keen interest in avoiding corruption and the state's keen interest in keeping the public confident in their government, that there's too strong of a position that the state has to the minor infringement on your rights or my rights when I was an elected official to speak about public business at certain times. So that's out there. I don't know whether they're going to take it to the U.S. Supreme Court, but so far they've not done well in court, and I guess they're going to fall back and think about it. Let's move on to issues that come up in open meetings first. The first thing we have to kind of do is define what is a meeting. And there is a much more substantial training that you're going to have to go through if you're new. You'll get a book. I think the books are actually in the materials you have. There's the Texas Attorney General's Open Meetings Handbook and the Texas Attorney General's Open Records Handbook that you have available to you, but you'll be going through a training on this. But I want you to think about what does it mean to say we're having a meeting? Everybody has sort of a general sense of what it means, but the law actually defines it very specifically. And a meeting is a deliberation between a quorum of a governmental body or between a quorum of a governmental body and another person. So we have to then define some further terms. What is a quorum? And for most people, it's just a majority of your board. For some cities, it's different. Their charters have different things, and I guess there are a couple of statutes that define a quorum differently for other bodies. But for the most part, it means a majority of whatever board you serve on. And then what does it mean to deliberate? We used to think it meant, and I think it was defined this way in the statute early on, that it meant that the board was talking to itself. The board members were speaking to each other about public business about which they have control and authority. And the statute was changed to specifically say it also includes situations where you're receiving information from another person, or that you're talking to another person about public business but not taking action. That was another thing we used to talk about a lot was, well, if we're not going to take any action, it's not really a meeting. And the law has been defined to remove all of that. So anytime a majority of you are together and someone is talking to you about public business, or you are talking to them about public business, or talking to each other about public business, you're holding a meeting. And of course, the meetings can only be held when they're properly posted, and the public has notice of the meetings, and there's an agenda. And you have to be careful to only talk about what's on the agenda. You'll go through those things more substantially in the Attorney General's training. There are some exceptions for attending things like this. This would not be a meeting if you have a majority of your members present at a local or regional or statewide conference. There is a specific provision in the law that says you can do that. You can come together, because we're technically talking public business right now. I'm giving you information about public business. If there's a quorum of you here, it could be a meeting, except for this exception. Another exception is for purely social events. So if you find yourselves all at the same cocktail party, or you go to a football game and you notice that you see 4 of you, in the same general area in the lounge, and people are talking about your university, that could be a meeting, but the law says social events where no public business is, specifically there to be discussed and no action is being taken is okay as well. What you do have to worry about, though, is the public perception. And that's a lot more for local people, I think, than maybe it is for you state level appointed officials. But certainly when I was a city council member and we would look around at Applebee's and there were 4 of us, at the same table, we would usually have one of us leave, or, we would move to different tables in different parts of the restaurant, because the public sees you all sitting there and they just assume, even though we may have been talking football or we may have been talking, raising children, they assume we're talking about running the city. So, and I have to say there's a great temptation to do that. I mean, anytime you can get everybody together outside of the TV cameras and outside the glare of the media, there is a temptation to say, let's talk quickly about this little topic here. We're not going to make any decisions. You have to avoid doing that. So one of the problems that I encountered in living under the open meetings law was the people I served on the city council with largely were some of my best friends. And it became difficult to have us get together because we were always worried about that perception. So keep the perception in mind just to avoid problems. You don't want to have to be giving interviews to the press about what you all were talking about that night at the cocktail party. So there is a concept in the law called a walking quorum, and this is something you should be very cautious about, particularly you new trustees and regents. If I go and talk to another person on the board I serve on, and then they go talk to another person, and they go talk to another person, and ultimately we have a quorum of us that have talked about a coming agenda item or something that's going on, and we've talked about how we might want to deal with it, and the information has sort of been, telephoned down the chain, the Attorney General says that is also a meeting. You have created a quorum not by all being in the same place at the same time, but by discussing the business over a period of time. There's also something known as a serial quorum, where I would go talk to one person, then I would go talk to another person, then I would go talk to another person, and effectively the same thing happens, that we talk about the public business, we discuss options, and we don't take any formal action, but we all know what's going to happen when we get to the meeting. And that's the kind of thing that the law does not like. A new and emerging field is what we refer to as an electronic quorum. If you're shooting emails around, I would urge all of you to just disable the reply all button on your email, because it can be problematic. If someone sends an email to the entire body and you hit reply all and respond back, and 2 or 3 other hit reply all and respond back, you may have unconsciously created a meeting by everybody discussing, deliberating a public topic where all of you got to see what everybody was talking about. So be aware of that. The law is also sort of behind the times on some other issues, and the legislature is wrestling with how to deal with things. The Open Meetings Handbook talks about Facebook. If somebody runs a Facebook page or has a blog where people can put comments, what if a majority or a quorum of your board are posting comments on somebody's blog about something they've written about? That could also potentially be considered to be a meeting. Now, no one has gone that far yet, but that is specifically something that the legislature is looking at, is how do we deal with emerging technology? And as usual, the law runs, almost a generation behind these sorts of things. So that is all stuff to be cautious about. I know I do work for cities and school districts and junior colleges and whatnot. I know city councils where more than one member runs a blog, and everybody reads their blog, and sometimes they post back and forth. You have to be cautious that those things somehow don't turn into a way to surreptitiously circumvent the law. So again, if you just sort of embrace the notion that we only should be talking public business when we're together, we should only be conducting public business when we're together in a properly called meeting, you'll avoid these sorts of problems. But it is a difficult field, and it is a bit of a challenge, and you don't often think about this when you're asked to run for office, or you're asked if you want to be appointed to a very high-level, prestigious position. No one talks to you about, and you may never get to talk to some of your friends again until you leave this board. So, or you can only talk to them when you're in public and there's a TV camera on you, which is always comforting. Let's shift over to open records, what is now called the Public Information Act, but it used to be called the Open Records Act. And since I started when it was that, I tend to call it that more often than not. The thing that I want you to think about and to bear in mind is the Act applies to more than just paper. It applies to information. And the Act applies to electronic information. So your email accounts that are your official, university at email accounts, those are public. And the general public or the town gadfly or your nemesis can just do an open records request and say, I want to see everything that's passed through that email account for the last month. And I've dealt with that before, or the last 4 months. And there are people that are just regular, we call them frequent flyers, that just every quarter they say, I want to see everything that went through that email account this quarter. And every email you sent out, every email you received is public record, presumably. Now there are exceptions that are relatively complicated, and I don't have enough time to really go into a lot of them here, but the Attorney General Handbook goes into it extensively, and of course the lawyers that represent you all are very well versed in these things. But you need to bear in mind, whatever I've put out there is potentially going to be on the front page of the paper. We had a very graphic example of this with the Austin City Council last year. The Austin Bulldog, sort of a watchdog organization, requested all of the city council members' email for a very long time. And most people don't do it because it's expensive, and these guys posted the money to do it. And the city hemmed and hawed, and there was a little bit of scrapping about what they had to produce or not produce. In the end, they got tons of this stuff, and it all became public. It all showed up in the Statesman, and there were some unflattering things in there. Some of the council members had written things about members of the public to the other council members. During the meeting, can you believe they're coming here again? And what is this stuff about? And that kind of stuff all became public, and it made them look relatively small and petty. That they're using time during a meeting when they should be focusing on the public and worrying about what the public wants to open up their email and pop out an email to other people who are sitting on the dais with them. And that's a concern for a lot of us. Is most people now have computers at their at their desks when they're working, and you can IM or you can text, or there's different ways to communicate with each other on the dais to where the public doesn't know what's going on. And again, the law is still trying to catch up with what that is. But by and large, that stuff is public. Regardless of whether it's a violation of the open meetings law, it is and can become public. And so think about that and act accordingly as you conduct the public business. So another aspect of this that has come up is that you may have personal email accounts that you had before you became appointed or elected, and that you've used for years to do business, and people may send you substantive about your elected or appointed life at that email account. If you correspond with them through that email account about public business, the Attorney General's position is those are also public, even though it's your personal private email account. And there's a bit of, it's been the law from the Attorney General's perspective for a number of years, so we're all sort of immune to it as lawyers. We see it and we deal with it. But it comes as a shock to a lot of elected officials when people say, and in my open records request wanting everything that went through your email account, I also want everything that went through your personal email account that is public record. And that puts the governmental organizations into a bit of a quandary because the staff has to go to the elected or appointed officials and say, either I need to look in your email account or I need you to look in your email account and forward me anything that is responsive to this request. And that puts the employees in an awkward position, to say the least. Some people are fighting back. There's a county commissioner from Bexar County, Tommy Atkinson, who has sued the Attorney General. Someone did an open records request to get his emails from his personal AOL account. Actually, I think he had 2 accounts. In particular, from a certain person that they knew was giving him information about a function of his. And he's refused to turn him over. The Attorney General said they had to turn him over. The issue that you go through when the Attorney General says produce it and you don't want to produce it is you sue the Attorney General. So he sued the Attorney General up here in Travis County. The court ruled back in March that he was wrong to, his position is wrong, and this is his position. That's my private stuff. I have a right of privacy. I shouldn't have to open it up for public display just because I've been elected or just because I've been appointed. And also, he's got a little more substantive argument, which is the act says that it pertains to information that is collected, assembled, or maintained by a governmental body or for a governmental body, and the governmental body has the right of access. And his position is they don't have a right of access to my personal email account, and they don't maintain it, they don't collect it, they don't assemble it, that's mine. And so far he has lost at the trial court level. He's of course lost with the Attorney General. His brief is due at the Third Court of Appeals here in Austin at the end of this month. So that issue will be joined, and perhaps by the time this conference goes on next year, we'll have an answer from the Austin Court of Appeals about whether your personal email accounts are somehow protected. Of course, the position that the Attorney General is promoting is we need to have open government. And if you can just avoid having the public know what you're doing in your email life by just doing it out of a private email account, then no one will ever see that. And there won't be any transparency, there won't be any openness, and there won't be any public confidence that what is going on is actually public government, not smoke-filled rooms, in this case, smoke-filled electronic rooms. So ultimately, bear that in mind too, that if what I would do, for instance, when people would send me email to my personal, my Hotmail account, was I would forward it to my city council account. And I would respond out of my city council account to it saying, please communicate with me here. But that way the record of it all went to the city's account, so the city always had it. And then finally, I'll leave you with the notion that the law requires retention of public records. And it's a fairly complicated and complex statute. It's in the Texas Archives Act. The Texas State Archives promulgates rules on this stuff. But there is no simple way to say, well, I can get rid of this stuff after 2 months or 6 months or a year. It depends on the nature of what the discussion is, what the information contains, and there are entire industries now that have arisen to try to help the government understand how to and when they can destroy records. The lesson for you as elected officials or appointed officials is be cautious when you're starting to delete things if you're going to delete them on a permanent basis. Most governmental bodies now have some sort of backup system where whatever goes through your email account is being stored on a central server somewhere or is being dumped down into a storage unit someplace that can be searched later. Because, like I say, it's very difficult to do this. I'll give you examples of the complexity. If you're talking about a personnel matter, you have to maintain any records relating to an employee's personnel records until 2 years after they've left the employment of the agency. So if you guys are shooting back and forth about the president and what you want to do about the president, that has to be kept until 2 years after that person's left. So you can't have an automatic delete on your system that goes away and disappears forever after 2 months or 6 months. So, and every category of information is structured that way. So the retention issues are very complex. What you should do perhaps as trustees or appointed officials is make sure your organization has some sort of backup system in place so that when you're deleting things out of your official account that there is a record of it somewhere and you're not accidentally destroying public records. And then just to sort of tie back around to the theme here, intentionally violating the open meetings law is a crime. You can serve up to 6 years in jail. The leading case on that I'm aware of is a school superintendent in the San Antonio area. They were at a school board president, not a superintendent, school board president. They were at a meeting, something came up. They asked their attorney who was present, can we talk about this in closed session? He said yes. They went into closed session. The local DA determined that they should not have done it in closed session and prosecuted, and the board president was convicted, even with the advice of his lawyer. The legislature later changed the statute to say that if your lawyer advises you in writing that you can talk about a topic in closed session, that's a defense. It doesn't mean you can't be charged, but it's a defense. So be very cautious about going into closed session about things that you're not sure about. Particularly, a lot of entities have what I call kind of a rollerball clause at the end of their agenda that we can go into closed session and talk about anything on this at any time, provided there's an exception. And be cautious about doing that. Make sure you ask your counsel, who should be present at the meetings, can we talk about this in closed session? Just to avoid those sorts of problems. And then on the open record side of things, destroying public records is also a criminal offense. I think it can rise to a Class A misdemeanor, or maybe even a felony. I think it stays at the misdemeanor level, but a Class A misdemeanor still gets you in jail and still gets you fined. So do not destroy public records knowingly and intentionally, and do not try to circumvent the open meetings law. Be sure and comply as best you can with being open, and your life will be a lot simpler from this perspective. And that's my time. Thank you.
Let me ask a couple questions just to follow up real quickly. What happens if a university's IT department decides that given the volume of emails, it's better to delete emails on a regularly scheduled basis? How would you handle that?
I think ultimately you've got to come up with a system that is in compliance with the retention laws. And I don't know that I don't believe an automatic destruction process will work for open records and for public records retention purposes. It's going to have to be a lot more sophisticated than that and a lot more complicated.
Okay, one other question. A university or a community college is contemplating buying some property. Maybe there's a good deal on the local mall.
Yes.
That could be had. But the local newspaper continually submits Public Information Act requests for documents concerning any negotiations going on over the proposed acquisition of the property. How would you handle that?
There is an exception in the Public Information Act that says that information regarding negotiations for purchase of real property by a governmental body can remain confidential. The Attorney General's interpretation is only so long as the negotiations are still going on. And so effectively, once you've signed a contract on the land and you're either going through due diligence or something like that, you then should have to produce the records to whoever has asked for it. There are ways to get around that. I hate to use those words, but to keep something confidential a little bit longer if you're engaged in a series of purchases. And I think this really started with TxDOT, because they often buy tracts of land, as they're building a road, they're buying as many of them as they can as they go along. And so if you're in the middle of buying multiple tracts of land as sort of one large acquisition, you can keep it confidential until the last one is acquired. And the reason for that exception is obvious. You don't want to harm the government's negotiating position. As much as we like open government, we also like our tax dollars even more. And we don't want to waste our tax dollars because everybody knows how much you paid for that tract over there, and they're going to want the exact same amount or higher. So the law does allow you to keep that information confidential, but only so long as you're still negotiating. Once you're under contract, it's a public matter.
Would that hold true if you're in the due diligence phase and the contract price could change depending on what's discovered during that phase?
What you'd have to do then is actually go to the Attorney General and ask for a ruling. Ultimately, in all these situations, the Attorney General is the one that tells us what we can withhold and not withhold. We don't get to do it on our own. So if you've got a question like that, and Bill's kind of joking around, I have a client that did buy them all over the span of 2.5 years, and we bought it in 5 different pieces, and we did get lots of requests from the media. We did have to go to the Attorney General a few times to say that things could change, or we were still in negotiation on another one, and the AG ruled accordingly. But if it's going to impact your negotiating position or impact the ultimate price that's being paid, if it becomes public, you have a good argument with the Attorney General.
Thank you. Next up is Mike Godfrey. And Mike is going to be discussing conflicts of interest, gifts, honoraria, and of course, interwoven with that will be ethical concerns. Mike?
Thank you, Bill. Let me start off by giving you the most important and what I hope for you is the most obvious. You may never accept any benefit in exchange for performing your official duties. We grew up with a term for that we all recognize. It's called bribery, and it will get you sent to prison. Having said that, I hope that got your attention. The common law rule on conflicts of interest has always been that there may never be any intersection between your private and your professional or service life. The Texas Ethics Commission fortunately says that is a standard beyond which we cannot expect people to comply. That invariably there are intersections between your personal and professional activities that are going to overlap. And as long as the overlap is de minimis, there should not be a problem. De minimis means you can call your spouse from your office phone before you leave to go home. You can use your computer for personal email messages, provided that you're not sending copious copies of cute cat videos that use up all of the server's space. But things that don't cost your institution any additional money are generally thought to be de minimis. Now, of course, if you spend all of your day sending cute cat videos around, you are depriving your employer of the value of your time as well, and that's frowned upon. These statutes dealing with conflicts of interest, to the extent that they have criminal implications, are enforced by your local county's district attorney. So I recommend to all of you, whenever you have any doubt about what you're doing, go visit with your district attorney and find out what his or her standard for conflicts of interest are in that county. I dealt with an assistant district attorney several years ago that was in charge of the public ethics section of the DA's office. And his view was public service is a privilege, and you should be so rigid in your separation of your public and private lives that you squeak when you walk. And I believe that was his term. A president of a component institution that happened to be in that county was on the board of directors of a major corporation. And he would have his assistant make his plane and hotel reservations for his attendance at corporate board meetings. And he would charge his airline ticket and his hotel to his university account. After the meeting, he would submit an expense report to the corporation. They would reimburse him for the expenses of attending the board meeting, and he would reimburse the university. We all thought, I say we, he didn't ask me, but he thought that that was a de minimis use of state assets. Well, the DA in that county tried twice to get him indicted for having done that. So just because your institution is advancing you a little money on a personal matter that you intend to fully reimburse after the fact may not sit well with the DA in the county where those activities are taking place. So don't just assume that if it's okay in Dallas County, that it will necessarily be okay in Kaufman County. The Texas Government Code has a large section devoted to ethics of government officials. And among the many statutes that are there are 5 should nots. The should nots are: you don't accept or solicit a gift, a favor, or a service that might reasonably affect your judgment as a public official. You should not accept employment that might require you to or induce you to disclose confidential information. I used to give this lecture when I was at UT to people that were new employees, and I always gave the example that if you work in the university's insurance group and you know that they're going to go out for a contract for a new policy to cover all of the employees of the institution, and that there are several large corporations that are going to be interested in bidding on that contract, and one of them offers you a job on Saturday morning at a very generous salary and very little work, they're probably not really interested in your employment activity there. They're interested in the information you can bring them about the bidding process. Don't accept employment or compensation that might impair your judgment. That's sort of the same coin, different side of the one just before. Don't make personal investments that might reasonably create a conflict of interest. Many, many years ago, whenever UTSA was first created, and it was operating out of an office park, there was huge discussion, debate among the Board of Regents about where to put the situs of the campus once it's finally going to be developed as a university. And once that announcement was made and the location of UTSA was set, it was discovered that several of the regents owned real estate right around there. In fact, they had recently bought real estate right around there. And when there was an outcry of, you guys are taking advantage of privileged information, their reaction was, no, we knew all the sites and bought real estate in all of them. So it didn't affect our judgment of where to put the university because we were going to make money wherever it was. Well, the short answer is don't do that. All those people are dead now, so I don't feel badly about exposing them. The statutes were not nearly as clear at that time, but at any rate, don't make personal investments that are going to affect your judgment or that will cause other people to think that it might affect your judgment. This is the classic, do you want to see it on the front page of the Sunday paper above the fold? Probably not. Don't intentionally or knowingly solicit or accept a benefit for having already exercised your duty. You did exactly what you were supposed to do, perfectly ethically, in good faith, and the beneficiary of your action comes to you after the fact and says, let me send you a case of whiskey. Well, no. Taking in a benefit after you've acted is frowned upon just as if you took the benefit before you acted, because nonetheless people will say, well, he knew what was behind the action down the road. He knew that he was going to get something after the fact that he couldn't take before the fact. There are a number of exceptions of things that you can do. It's sort of where your public life and your private life overlap. The statute has been in the past that if you are an shareholder or a director of a company, your institution can nonetheless do business with your company subject to certain disclosures and restrictions. But the statute and the Attorney General's opinion that built on the statute, and the gentleman here who probably dealt with that case at TWU said, if you are an officer or an employee of that institution, you are precluded from being on the board of an institution doing business with your business where you are an officer and employee. This was TWU had a banker, local banker on its board, and TWU was doing business with the bank. And they said the statute is clear, you know, that if you're an officer and employee, you can't do that. Well, frankly, that was too harsh, and the last session of the legislature fixed it. If you are associated with a nonprofit corporation, then your business, your institution can do business with that nonprofit corporation regardless of your status. If you are a shareholder or receive a substantial benefit from a corporation, your institution that you serve can still do business with that corporation, provided that you disclose your interest in an open meeting and do not vote on it. The same rule now applies to officers and employees of a company with which your institution wants to do business. So if you're a trustee at TWU now and you're a banker, TWU can still do business with your bank provided you disclose your relationship with the bank in an open meeting and then decline to vote or don't vote on the matter. Honoraria. If you are off speaking somewhere, you may accept an honorarium provided that you are not speaking in your official capacity. If you are invited to speak because you're a regent, a trustee, a president, or a vice president, you may not accept an honorarium for that speech. But if you're giving a speech on beekeeping because you know all there is to know about beekeeping, you may accept an honorarium, and that is not a problem. At the end of your speech, you may accept a token. A token is a coffee mug, a plaque, some other modest recognition, but nothing of any significant value. You may accept costs associated with attending the meeting where you spoke. That is, they can pay your transportation and your hotel bill and your food bill while you're there, provided that you are there speaking on a substantive matter and not just as a perfunctory excuse to get you to the meeting at their expense. So if you're making a significant contribution to the importance of the meeting, then you may accept reimbursement for transportation and lodging and food, but you can't just get up and wave and say, I'm here on behalf of my institution, and sit back down and expect that to work. There are specialized rules dealing with registered lobbyists. I won't go into those because they're very complex, but my experience is registered lobbyists know what the rules are, and they don't want to get themselves in trouble, and they particularly don't want to get you in trouble because it would destroy the value of their lobbying effort if suddenly you were caught short because the lobby rules were not complied with. This is an interesting one. This is actually in statute. You may keep your frequent flyer miles. Even if you're traveling on university business, college business, whatever, somebody finally figured out a long time ago that trying to keep track of frequent flyer miles was going to be far more expensive than whatever value those frequent flyer miles might have been. They used to be worth about a penny a mile. I think they're worth much less than that now. So I think that was a reasonable decision to say you can keep your frequent flyer miles. You can obviously accept gifts from your family and from relatives and from good friends that are not related to your service. So at Christmas time, if you're a trustee or a regent or a president and your wife gives you a very expensive watch, you may keep the watch. It's not going to get you in trouble. From time to time, God, there must have been a lot of people around the room that were concerned about that. From time to time, it's either too awkward or too difficult or whatever to return a gift that would otherwise put you in jeopardy. In that instance, you can avoid risk and liability by transferring that gift to a charitable institution, religious, educational, scientific, or whatever, for their use, not for yours. The one that keeps cropping up because it's so easy is at Christmas time you get a very expensive gift basket, and it's got cheese and fruit and nuts and a couple of bottles of wine in it, and all of a sudden that basket costs $85. Well, that clearly breaks the $50 rule. But if you want to use it for your institution's Christmas party on the premises and make it available to all of your colleagues, you'll be okay. If you get that wonderful flat screen TV that's 48 inches and you just voted on a contract where they wanted to show their appreciation, you can give that TV to your institution. You give it to your church. You're not obligated necessarily to give it to your institution, but if you give it to a recognized charitable institution, that avoids your risk or liability. My friend Fernando pointed out that there is one other new exception that was passed in the last session of the legislature that says neither the institution nor the recipient violates the law if they give or receive an item issued by a governmental entity that allows the use of property or facilities owned, leased, or operated by the governmental entity. Governor Perry swims in the UT swimming pool. When he was Chief Justice of the Supreme Court, because it required, equal treatment of all branches of government, the Chief Justice took advantage of the same privilege that was extended to Governor Perry. Now, whether or not this is what that was intended to cover or not, I have no idea. Fernando says it's intended to cover tickets to football games, and that is at least as good an explanation for that language as anything I could possibly come up with. I mentioned already, and I want to underscore it, don't take a chance with your local district attorney. Find out what they think the law is that they're going to enforce in your county. The Texas Ethics Commission does a wonderful job of describing what your responsibilities are, how the law applies, but they're not the people that ultimately enforce the law. Fortunately, they are the people that published this wonderful 12-page pamphlet entitled A Guide to Ethics Laws for State Officers and Employees. It's readily available on their website, and it's easy to find on their website, or I'd give you the citation. I'm sorry? Part of the packet. Oh, it's part of the packet, even better. The answer to virtually any question you're going to have is encapsulated in these 12 pages, and I commend it to you. So thank you very much.
Thank you, Mike. Just a couple quick questions, and then we'll open it to the audience. What if an individual who's working at an institution such as a community college or a university is offered airfare and lodging to attend a trade show to view a vendor's product related to something that his or her campus clearly has a need for? How would you handle that?
The way that that has been interpreted or applied is if there's value to the institution by someone going to the trade show because it is something that will add to the institution's information about something that they may want to acquire, the institution can accept the offer of transportation and lodging and designate an employee to take advantage of it. The employee himself or herself may not make that judgment. So you're the head of purchasing, somebody wants to pay your way to a trade show, your institution can accept that offer, and they may send you or they may send somebody else. But you individually cannot make a decision to accept that offer.
But the institution could end up sending the employee who in the first instance actually received the offer.
And frequently does, because that's generally extended to that employee because they're the one that's most directly involved in whatever the transaction might be.
Last question from me. And you touched on this a little bit, but are there any special rules related to meals and entertainment?
The rule with respect to meals and entertainment is your host must be present. There is no limitation on the value of meals or entertainment that you may receive, provided that your host is present at the time. The host can't just send a $100 gift card to a local restaurant and say, take your spouse out and have a good time. Having said that there is no limitation on the value of what meals and entertainment is, I think there's, the rule of common sense. The copy gave the example of having dinner at Applebee's. Well, I don't think anybody's going to get seriously exercised if somebody takes you to dinner at Applebee's. If they took you to dinner 5 nights in a row at the Four Seasons, somebody might think that that was a bit excessive.
Maybe even 3 nights in a row.
Maybe 3 nights in a row.
Thank you. Any questions from anybody in the audience? We're available. Yes, sir.
I have 2 questions. The first one is, can you, or in a duly convened meeting, can either the president or any of the board of trustees be texting? That's the first question. The other one relates to executive session. We've had this conversation on our board with basically, are we required, and I think that's what we're required, to document the whatever we are doing in executive session or recorded in some way?
You can record the executive session. What I understand most entities normally do is simply have an agenda for the session and then indicate at the end of the session that the agenda was followed, so that there is probably what amounts to about a half a page record of that executive session. You have to, of course, note when you go into the executive session, the statutory section that allows you to do so. You need to note the time, and when you come out of executive session, you need to note the time as well. As to your first question, can you text during a board meeting? Yes, is the answer. Presuming the question means are you texting in regard to business going on at the meeting or that could be conducted at the meeting?
Well, I think that the perception might be that, somebody may be texting somebody else about the meeting. I think that's...
Well, as Kabi pointed out, you can do it, but you might want to question how wise it is to do it, because if an individual were to submit a Public Information Act request and your text related to the business at hand, that request, in order to be fulfilled, your text would have to be turned over. So again, I question how wise it is to be texting, but you can go ahead and text. And Mary tells me, whoops.
We're going to need to take a break, so if you have a specific question, I would suggest that you take a break time and ask it on.
Okay. Perfect. We'll be happy to stay up here until the next section is ready to start. Thank you all.
Honorable man,